So in terms of the thing I wanted to talk about, so I was delivering training to a council, which I'm not going to name, not for any particular reason, but I just think it doesn't necessarily add to it, and I just don't want to get them in any trouble. So it was essentially a group of mental health professionals, social workers. Basically, there was a children's social worker as well. There was an OT, and there was a mixture of amps and kind of very experienced, senior people. Really, really cool group to train. And in their area, they dealt with, I think, something like 5 different housing authorities, and what they were consistently getting for their clients or patients, I'm not quite sure what the right term is for them, was that the housing authorities were refusing to take applications because they judged the person's mental capacity to kind of be lacking, and therefore they were kind of using the Begum case to say, well, if you don't have mental capacity, you can't make an application, therefore we don't have to do anything. And this was for people who there was no reason to doubt they had capacity to make a homelessness application itself. There might be other kind of difficulties they might be experiencing, but there was no or very little indication in most cases where the person lacked capacity. And what the housing authority was saying to them was that, when the mental health worker was saying, well, look, we're mental health professionals, we have assessed this person's capacity, we don't even have concerns about this person's capacity to make an application. The housing authority was saying, yeah, but we do a different test. We assess mental capacity differently. So, so you're not going to win this one, basically. And so they were pushing. I got the impression potentially scores of people every year away from the housing authority kind of duties and onto social care, which, they were kind of pointing out was costing thousands of pounds a week to kind of place people. So, yeah, that's what I wanted to start, really. We kind of talked just before this and kind of said, actually, we couldn't find the Begum case on Bailey or anything like that in terms of there being a transcript, but it was referred to within another case, WB v someone, I can't remember, it was all anonymised.
WB, I'm not saying this off the top of my head, WB, a protected party through a litigation-friendly official solicitor versus W District Council, and that was 2018, which was a lot later than Begum, which is 93. And I think the reason Begum can't be found so easily is because it predates the days when scripts and things were made available on Bailey or other places. But WB is available, which does give a summary. It's a while since I read it.
So I was looking through it, and as a layperson, there's a lot. I mean, essentially, it was helpful to a degree, but a lot of that case was actually about whether, kind of was the nuts and bolts of the way legislation kind of built upon itself, and whether it was, whether the original 1993 decision was still valid, given that the Human Rights Act and the kind of the Equality Act had happened since then. So in one sense, as a layperson myself, I'm looking for a very practical answer of what does a mental health professional do when faced with that response from housing, and is there, what would their line of argument be to kind of get that person's application accepted? But yeah, you may well have some other stuff you want to say as well.
I've got a question I wanted to ask just before diving into the sort of legal issues about what happens if somebody doesn't have capacity. But what was the basis of the local authority assessment? Was that a housing officer doing their own sort of amateur assessment, or did they have a sort of social worker or psychiatrist on hand?
So I don't know for sure. These were kind of questions I put back to them. My guess is they've basically got hold of a template from somewhere, from some unscrupulous review company or whatever, and they kind of use that so as soon as they see mental health issue at all, they're like, oh, that person lacks capacity, therefore we can throw this template at them. It seemed to me to be so far-fetched that no actual competent solicitor or something in their authority would recommend using that line of defense, but that was kind of what they're faced with. So I don't know for sure is the answer, but I think they simply had untrained housing officers who probably didn't even know what a mental capacity assessment was and what's involved, and they were simply seeing someone with difficulties and then saying, well, this person doesn't have capacity to manage a tenancy, therefore we don't have to accept the application, which I think actually might even be a step too far anyway, because when I was reading the WB case, it talks about the capacity to ask for help, the capacity to instruct someone on their behalf, and in WB's case, essentially the numerous judges had said this person, she doesn't have capacity to manage her own affairs at all, really. Although she disputed that, but that's kind of their assessment. So yeah, my guess is that they simply are Wild Westing it, and they don't have any good reason.
Because I think it might be open to challenge. The approach might be open to challenge or severe criticism without going just based on the assessment. Because if the applicant, the Mental Capacity Act 2005, which I think is the law where this stuff is found, says that there's a presumption that somebody does have capacity unless you can prove otherwise. And so you'd have to say, well, what's the basis of your assessment? And if it's just, well, I'm a housing officer and I think you're acting a bit strangely, so you must have mental health problems. And then the other thing is that even once you've got the presumption out of the way, capacity is issue specific. So you could lack capacity to do certain things, but not others. And I was involved in a court case in the Court of Protection where we were going to have to argue what it was that you would have to have capacity to do in order to enter into a tenancy. And the problem with it was a bit like the sort of movie Gremlins, that things kept popping off the back of it, because you think, well, there's hundreds of things you've got to be able to do, and it becomes, you've got to be able to think about paying the rent. Because on some levels you could say, well, you've got capacity do you realise that if you don't pay the rent, you'll get evicted? And you go, yes. Oh, you've got capacity. But of course you haven't, because you haven't got capacity to apply for, you might not know how to, or not be able to apply for housing benefit. You might not be able to engage with housing officers. So there's quite a lot there, and quite a sort of, it's not just a question of saying, I thought you seemed a bit warmed out, so I think you lack capacity. So that's issue number one. And then the other question I'm just thinking is, I think I've become a sort of enormous fan, and it sounds like I'm obsessed with the Homelessness Reduction Act, but notice that WB is a 2018 case, and the point there is that the decisions in there would have predated the introduction of the Homelessness Reduction Act and the amendments to the Act. So then, because I was thinking about this point you made about them refusing to take an application, because that's the old sort of classic gatekeeping thing. No, we're not even taking an application. And then people like us would say, well, you've got to take an application. You can do a negative decision if you like, but you can't refuse to. Section 184 means you have to make inquiries. And so they might say, well, no, we don't, because we don't think you've got capacity to make an application, so we don't have to take it. But that would give them a license to gatekeep anybody they thought seemed a bit unusual. But then the Homelessness Reduction Act, if you think about it, it widens the duties. Because, for instance, if somebody who lacks capacity was facing eviction, or they'd received a Section 21 notice, you're not asking for help to enter into a new tenancy. You're just asking for help in avoiding the loss of your home. So do you need capacity for that? Then you'd think, well, they might have to draw up a personal housing plan. And then the other thing, at the end of my long response, is that this thing about, it may not be the end of the world if they do refuse to take an application under Part 7, as long as they say, but we are making a referral to adult social services who happen to be in the building, and they will talk to you now about assessing your need for support services, including accommodation. And then that's okay, I'd have thought, because you're getting accommodation.
I think the issue is because social workers aren't geared up to source housing. What they're finding, and that's essentially the current thing, is that the emails are sort of saying, well, look, this person doesn't have capacity, therefore it's adult social care's problem. You guys go and find accommodation. But in reality, they're not, they're social workers. They're not geared up to source accommodation. They don't have access to to kind of rent deposit scheme type stuff. And so they ultimately they're ending up putting people in respite care at £1,000 a week or whatever silly number they come up with. And it seems to me that actually, although I'm sure there are going to be situations where certain individuals really do lack capacity to kind of to make an application, generally speaking, they do have capacity to kind of to get that far, and simply the housing authority is pushing people away and just using it as a gatekeeping tactic. So so reading up on the WB case, this is where it gets confusing, and this is why I was frustrated I couldn't find the original Begum case, because at some points it's literally just saying it's just a question of whether someone has mental capacity to make an application, as in approach an authority and ask for help. That's kind of the way it's kind of, some sentences are saying, and then other times it's referring to capacity to understand the requirements of a tenancy. But I think we're probably talking about people here who are completely able to understand the kind of the requirements of a tenancy. They understand they have to pay rent, they understand they can get help to pay rent. And really, it's kind of these are people who actually are bread and butter of homelessness services in general, and simply aren't being helped when they should be. And on the training, the day we kind of got onto intentionality, where it talks about someone who became homeless because of an aberration of their mind and therefore shouldn't be intentionally homeless, and that would kind of again just infer that yes, homeless officers are going to be dealing with people whose mental capacity fluctuates They may have some significant issues, but that nonetheless, they should be making, they should be taking applications from them. So I think that's I'd be interested to kind of find out more detail on, what is it someone needs capacity to do.
My understanding, Mike, is that the thing you've got to have capacity to do is to enter into a tenancy agreement. Because if you can't do that, there's no point in applying for one. And I think that's the thing you're looking at, because the capacity to walk into the council and ask for help is much lower threshold.
Okay.
And the other interesting thing, of course, is that, and I've reminded of this when I was checking this afternoon, is the WB case started off as an intentional homelessness case. And I think they raised mental health within the case. And the judge at the 204 appeal said, I don't think you've got capacity to be a party. And then once they got the official solicitor involved and they got an assessment, they found that the capacity was even less. And they then withdrew the intentional homeless decision and said, well, you haven't got capacity to make an application at all. So we'll get you on that one. But I think that's what the test is, but I don't think there's ever been a lot of argument about, forgive me, I haven't read WB for a while, but there must have been some discussion in there about quite what capacity is, what you need to be able to do in order to have
that's the kind of section which, as I say, at certain times it's saying it's incredibly low, and other times it does mention the kind of the capacity to, as you say, the capacity to enter into a tenancy. So what I have read, what I could find on the Bagan case, is that the daughter who was kind of the one who wanted to make the application, or who the family wanted to make the application, was literally unable to to understand anything, was unable to have any sort of kind of cogent conversation with anyone about anything. And that was the kind of, for someone who literally cannot understand any of this process, that would be that's a situation where they wouldn't be able to make an application. But as I say, the majority of people who are accessing mental health services who have AMPs involved and so on are going to be people who most of the time they have capacity, if not all the time. And when they don't have capacity, they may end up getting sectioned or whatever under the Mental Health Act. But by and large, they're people who have a right to have to access a tenancy. And in my my own personal views are that most people actually can maintain a tenancy surprisingly well if it's the right one for them and they have the right support involved. So if you've got a social worker involved, then they're someone who can help making housing benefit claims and help kind of with those nuts and bolts. So I guess I've got two more further questions on this one. So one is, if someone genuinely lacks capacity, can they then, and I think this again is inferred within the WB case, can there be a deputy appointed to make decisions in their best interest, and could that involve making a homeless application? Because that seems to me to be kind of almost the way of getting around it.
Well, it is. I was just looking at this earlier on today, because the issue would be you either go to ask for accommodation under the Care Act, which, like you say, is difficult because there's not a very clear procedure or a housing stock available for that. But then the alternative would be to get a deputy appointed in the Court of Protection, and then the deputy can do things and could enter into a tenancy agreement on behalf of the applicant and therefore pursue the homelessness application. But having said that, of course, making an application to the Court of Protection is quite a difficult thing to do for most people.
Well, I think with this group of like these AMPs and these, I think actually that might be something which is quite familiar to them. I might be wrong, but I guess certainly kind of the social workers I've worked with, they are familiar with that process. They're in court, in the Court of Protection, if that's the right term for it, regularly. And I think if I was to go back to them and say, actually, okay, go down the Court of Protection and kind of get a deputy appointed, I think they'd be like, oh yeah, that's nice and easy. We know the judge's name, by name.
If you can find out about that, I'd be really interested to hear, because for solicitors, the Court of Protection is a sort of mystical, mysterious place with all sorts of, and there's a tendency among, I may be being unkind, but amongst the practitioners who work in there and have a degree of specialization, to make it sound even worse, more difficult than it is, because there's a tendency to refer to all these COP forms, which is Court of Protection form, but you're talking about, you've got to do a COP 23 and then a COP 7, and you think, oh geez, I'm going to mess this up, and it's
well, I've got news for you, Will. Like that's like everything for me. Like I read these transcripts, and I'm like, I don't even like that one you read out earlier, the WB one. I'm assuming they've done that because it's kept entirely anonymous. That's
yes.
why it sounds so weird, like such a weird title. But I'm like, yeah, it's all gobbledygook to me. But yeah, the actual bits which are important generally make sense. sense. Although, as I say, in that case, it's largely a discussion around the, can you set aside the previous case law, but that's another issue. So that's my final question about this one then is, so court of protection may be a solution to the situation, but if that isn't a solution, what else can those social workers do? How do you challenge a council who's refusing to take an application? Is it judicial review?
I think it would be, because it's a traditional gatekeeping simple gatekeeping judicial review. The relief duty is triggered simply on the basis of somebody being homeless and eligible. It doesn't say anything about having capacity. So I would have thought that if they say we're not going to process this because you haven't got capacity, you could say, well, that's unlawful because you don't have to consider capacity at this stage. They may say, oh, well, if you read the detail of WB and Begum, you do. But that would be interesting, because I think that the issue, if capacity, obviously if the applicant said, yes, I accept that I haven't got capacity, because presumably they wouldn't be able to express such a pronounced view. But if it was accepted that they did lack capacity, then I think it might be seen as a bit of an abuse to run the argument. But if it's disputed and the social worker says, yeah, I don't agree that this person lacks capacity, you then need to get a determination of capacity. And this is disputed. I spend a lot of time in other areas of my work getting certificates of capacity completed. And generally, you need to get a consultant psychiatrist. You can sometimes persuade a GP to do it, but they tend to be really scared of expressing views on mental health. Social workers, I did want to have a social worker do one. They can do it, but really you want to get a psychiatrist. So you would then say to challenge it, you'd say, well, we don't accept that this person lacks capacity. Where's your evidence? And if it's just an attendance note saying person seems to be a bit unusual, a bit strange, then I'd have thought that's completely unlawful.
This leads on to some questions just on the back of that then. So, and this is one of the things I've gone back, and this might be, again, something you might know the answer to, but so institutional abuse. So back in 2019 in Bedford Borough Council, we had a spate of horrific housing officers, and we ended up raising a safeguarding alert on the basis of institutional abuse. They were just literally refusing to consider someone's vulnerabilities, even when someone was very clearly vulnerable. They weren't even entertaining or weren't even engaging with the kind of inquiries into to vulnerability. So we raised a safeguarding alert and saying, look, all the guidance around safeguarding alerts and institutional abuse talk about care settings, and housing option services are not care settings. But nonetheless, we raised it. It got the job done, and I pushed the senior social worker in Bedford for an answer and said, was this institutional abuse? And she never replied to me, which says to me it probably was, and she just didn't want to say it. But I just want, so that's one thing I've gone back to this council and said, if you've got a systemic problem where people with mental health diagnoses are being denied the right to make a homeless application because of purported lack of capacity, when actually there are no such issues, then I would say that would be in the ballpark of institutional abuse, and therefore a safeguarding alert could be raised, or maybe should be raised if I'm right. And that might then lead to the housing team having a bit of a wake-up call of actually what they're doing is just not okay. So yeah, that's kind of, I don't know if you've got any opinions about whether any kind of gatekeeping practice might at some point be considered to be institutional abuse.
I haven't actually come across institutional abuse as something I've worked on, but I was thinking whether it might amount to disability discrimination, in the sense that if somebody does have a mental health problem, presumably it's a form of discrimination if you say, well, you have mental health problem A, but I'm going to treat you as if you've got mental health problems B, C, D, E, F, and I'm going to refuse to accept a homeless application from you. Then you're treating them adversely as a result of something arising out of a disability, which happens to be your prejudiced or your opportunist interpretation of their condition. Or, that's all, well, I'm not going to talk to him because he's mentally ill. So, that would be quite serious discrimination.
I think it would be. And so my actual final question, I know I've said I've already had a final question, would be, because ultimately, what I'm hoping is to go back to this team and say, look, I can help you out with let's just try one case. Let's get a case where this, someone definitely has capacity. There's no doubt about they've got capacity, and yet the housing team are saying they don't, and run with it. And I guess my question would be is, because my usual stuff would be, okay, make a complaint, potentially raise a safeguarding alert. But in terms of going to judicial review, and I know this is probably not a question that we can finish here, but I could presumably write a pre-action letter and just, kind of cite these reasons and say, let's just get this settled and kind of into a court. And then we just, so the pre-action letter goes in. Let's say the council just holds their ground. We're going to need to get a solicitor, presumably, to actually do that final process of actually going into court and making these arguments. That might be something I'll contact you about at due course.
Yeah, I do. And if you need any help with the pre-action letter, I could cobble something together now so you've got something to show them. Because I think it would be a really simple one saying, I mean, I've got a standard gatekeeping template that I use to say refusing to process an application. So you then just stick in an extra couple of paragraphs to say there is such a thing of lack of capacity, but you haven't done an assessment, so you can't rely on that at the moment, and it's disputed. So I think they'd still have to process, because that's partly what a housing needs assessment is about. If the assessment comes up with them lacking capacity, then also the code of guidance says how you should then make a referral to adult social services. But anyway, so I think you'd have a really good straightforward JR, and they would get into trouble, I think, if they made unqualified assessments. And I think a judge would say, well, it's obviously it's just gatekeeping dressed up as mental health assessment.
Yeah.
So that's I mean, I could talk about, I found the issue of mental capacity without wishing to draw it out longer than necessary, but it's really fascinating because it keeps coming up in possession cases where somebody lacks capacity, and that's the capacity to instruct us to conduct litigation. And it just comes up time and again, and the threshold's much lower, I think, than people realise, because you think, to some extent, when you say mental health problem and capacity, you're almost thinking of psychosis and coma and things like that, where it could just be a level of depression which is such that you would get so upset at confronting these issues that you can't. And without labouring it, the issue is whether you can, in terms of capacity to instruct a solicitor, I think it's a slightly artificial concept anyway, because I think most people lack capacity to instruct a solicitor, in the same way that you and I, unless you have dentist skills that I don't know of, but if I go to the dentist and I haven't got the capacity to give them instructions. They can say something to me which I can barely understand because it's technical talk, but I can't say, oh no, I think you should do this, this, and this. I haven't got capacity to do that. So I sort of lack capacity, and you just go along with what they say. And I think the thing with the legal capacity is quite similar in lots of ways. I think the idea is that people would have the confidence maybe to say, what exactly are you on about on that point, whereas somebody who lacks capacity might not. But I'm really finding a lot of cases, just about most cases involving hoarding and things like that, I'm finding that capacity and mental health are highly relevant and make all the difference, because once you get a lack of capacity, you've then got disability, and you've then got a counterclaim on the defence and an entitlement to a lot of compensation.